Now, the ongoing contentious debate is sparking legal questions as well tonight. Good Day Virginia anchor Amanda Kenny spoke with a trio of legal and political experts about not only the possibility of a landmark change, but the ripple effect it could have.
The Supreme Court draft opinion written by Justice Alito is just that, says Radford University's Dr. Allison Yankel.
It's not the final version of the opinion that we'll see in June, or at least it might not be the final version of the opinion we see in June.
A number of possible things that can happen between now and the release of the final judgment.
Morse Tan, dean at Liberty University School of Law, says this leaked draft can have consequences for the Supreme Court.
It really compromises the process that the justices are going in and subjects them potentially to external pressures that would not have been there otherwise.
But if the draft doesn't change, the Supreme Court will overturn Roe v. Wade. Dr. Yankel says this also overturns the 1992 ruling of Planned Parenthood versus Casey, which affirmed Roe v. Wade, but also established what's called undue burden, which means a state restriction cannot create substantial obstacles for women seeking an abortion.
And the court is finding that not only is this idea of is there an undue burden really not necessary, but this idea of a right to privacy in order to receive an abortion is not constitutional. That the court made the wrong decision in Roe v. Wade when they voted 7-2 to extend that right across the United States.
What they're saying is the Bill of Rights, the first 10 amendments of the Constitution, lay out different rights that we have. But there is no explicit discussion of reproductive freedom or a general right to privacy.
Roanoke College political professor Dr. Todd Peppers says some justices believe that if it's not specifically written into the Constitution, then the federal Bill of Rights has nothing to say about it.
Historically in this country, the states have been considered to be in the driver's seat when it comes to issues of public health or morality or police powers, and that this general right to privacy should be protected by the states, not the federal government. That's sort of what the argument is over is, we have this grand blueprint of government that's been around for well over 200 years, and we're still having disagreements about what that blueprint says.
That's exactly what Tan says Justice Alito spells out in the draft.
This opinion stays as it is. He is kicking it back to the states, to the people and to the people's representatives in each state.
He says Justice Alito believes the Supreme Court got it wrong on Roe v. Wade in 1973.
Something that was criminalized with jail time, with fines, could be somehow magically turned into a constitutional right. Justice Alito doesn't buy that, and he spends a lot of time debunking that theme.
Dr. Yankel says states aren't wasting any time either.
Already seen aspects of some states moving to protect the right to abortion, even if Roe is repealed, while you have other states that are saying, what can we prepare in order to restrict abortion or potentially make it illegal?
But all of our experts agree. Drafts are written and rewritten, and some justices change their mind. So Americans won't likely know the outcome until June. Local in Roanoke, Amanda Kenny, WFXR News.